Hello and welcome to the next instalment of In Conversation with Ridouts. This is our series of short videos where we take a look at some of the issues affecting providers in the health and social care sector. My name is Maddi Gaunt. I'm one of the solicitors here at Ridouts. I'm joined by Caroline Barker, our director, and Samantha Cox, associate solicitor. And in today's video, we're going to consider the role of the Office for Standards in Education, Children's Services and Skills, or Ofsted, who, alongside their role in the education sector, inspects and regulates providers of health and social care services to children in England and Wales. So, Caroline, what is Ofsted like as a regulator, and is there anything providers should be aware of?
Sure. We've been helping providers of children's social care for a number of years in their dealings with Ofsted. And it might be through direct dealings, such as a factual accuracy comment, response to an inspection report that providers don't agree with, perhaps a complaint against the judgments that are made in an inspection report or the behaviour of an inspector, or enforcement action more generally. We also help providers with matters where Ofsted are on the periphery, such as serious case reviews where a child has died in a children's home, or there's a LADO investigation following a safeguarding alert. Ofsted have an important role to play in regulating children's social care services, but we found at Ridouts that over the last few years they've become more entrenched in their decision making. They're quite a difficult regulator. With CQC will at least on the whole listen to what we've got to say and reconsider sometimes their decisions, whereas Ofsted are becoming more entrenched, as I said, and digging their heels in. So it can be quite difficult for providers when challenging Ofsted. Ofsted really don't like to be challenged, but there can sometimes be an inconsistency in their approach. So, for example, they say that you can't challenge compliance notices, but actually at Ridouts we've successfully achieved some compliance notices being withdrawn. There are some positives around Ofsted. CQC borrowed the requires improvement rating when it had adopted its new rating system. But even last year, Labour was calling for Ofsted to be scrapped because it wasn't fit for purpose. So I think there's some divided opinion over Ofsted. So
it sounds like they can be a little bit heavy-handed as a regulator, but I suppose, as you say, they have got an important job to do. So Sam, can you tell me a bit about what are Ofsted's enforcement powers and when might children home providers see Ofsted using these powers?
Sure. I mean, I'll start with how you might see them being used or when they might come across them. So enforcement action normally follows inspection. Now this could be a routine inspection or it could be prompted by certain events. So for example, a safeguarding alert, a specific incident at the home or service and or complaints. And these would prompt Ofsted to come in and have a look at compliance at the service and levels of risk. So there's a range of enforcement action Ofsted can take. The whole purpose of Ofsted enforcement action is to decrease risk, enforce compliance and to increase quality at a service. There's a couple of different types of enforcement action that Ofsted can take. That ranges from non-statutory, so it's noted in their guidance, or there's also statutory enforcement action that's conferred under the Care Standards Act 2000 and associated regulations. So some examples of the non-statutory enforcement powers which are set out in their guidance include the issuing of requirements or recommendations which are normally noted in the inspection report. Mm-hmm. Now, more importantly that I want to talk about today are some of the statutory enforcement powers, as I say, set under the Care Standards Act. Now, three of the key powers I would say that providers should really ensure that they're aware of and know that Ofsted can do are the restriction of accommodation, suspension of registration and cancellation of registration. Now, these are at the much higher end of Ofsted's enforcement powers and providers really need to take note because of how this can be done and the potential implications that can result from this type of enforcement power action.
So you focused then on three particular kind of enforcement. Could you tell me a little bit more about those, please?
I can talk about restrictions of admissions. So a restriction of admissions is a document where once served it takes effect immediately, and it means that a provider can no longer admit any further young people to its home. It can actually keep the young people who already are residing at the home but can't take any further admissions. They're normally imposed for a period of 12 weeks, and it varies from case to case, but that's the standard, tends to be the standard period of time that Ofsted impose a restriction for. Now, they're imposed when Ofsted reasonably believes that a child, young person or adult may be at risk of harm. So it's not necessarily just in relation to the young people in the home, it could be a staff member too that they've got a concern around. So as I say, it takes effect immediately. There's no statutory test, but Ofsted have to give reasons when serving this notice. And they're normally imposed when there is, as I say, a risk. So either where there's an investigation being carried out into the risk, perhaps under section 47, or where the risk can be reduced or eliminated. The notice is actually sent to all local authorities in the country to notify them that they can no longer send children to those particular homes. So it has some very big implications for providers. And whilst we've mentioned that homes can keep the young people that they currently have residing in the home, we've often find that local authorities are quite twitchy around restrictions of accommodation, and it has resulted in local authorities actually pulling children from a home, which can have a further impact on providers. So Ofsted are actually supposed to keep restrictions of accommodations under review, and at Ridouts we've actually helped providers by compiling information and presenting it to Ofsted within the initial restriction period, which resulted in that restriction no longer being applicable and the restriction lifted before the 12 weeks. In addition, providers also have the right to appeal to the First Tier Tribunal. And again, at Ridouts, we have successfully helped a provider who had a restriction of accommodation served on them, which we didn't think was warranted. So we put in an application to the First Tier Tribunal, and shortly afterwards, Ofsted said they weren't going to oppose our appeal and lifted the restriction immediately. So we didn't even get to the full hearing of a First Tier Tribunal, but Ofsted realised that there weren't really grounds to impose the restriction in the first place.
And I'll just cover the suspension and cancellation here as well. So for suspension of registration, so this means that Ofsted is basically pausing a provider's registration. The registration remains intact, but it means that during the suspension period, the provider is not able to accommodate children at that time. Now, a suspension can be imposed either urgently or non-urgently. If it's non-urgent, there's the opportunity to respond to a notice of proposal. You have 28 days to do that, and then if Ofsted want to continue, it has to go to appeal, which would be through an independent tribunal. If a suspension is applied, then it's an offence to not comply with the suspension. So if you were to continue to accommodate children in your service while the suspension is in place, then that is a statutory offence that could be prosecutable. And the implications of a suspension means that all children have to be removed from the home at the time that the suspension takes place. So it has a big impact on the provider. It's very serious. Ofsted will speak to relevant placing authorities in terms of where the children should go during the suspension period. Now, we've seen a couple of these be applied, and in these circumstances, the young people have either gone to other services, or they've gone back home for a temporary period, or they've gone with foster carers. They normally happen quite last minute, and so arrangements have to be made fairly promptly, and they might not be the most ideal situation for the young person, but if Ofsted believes that there's a sufficient level of risk for them to impose a suspension, then they will do that. As I've said, there's the opportunity to appeal suspensions, but Ofsted are also required to keep suspensions under review. Now, a normal suspension would last initially for 12 weeks, and Ofsted have to review that twice within the suspension period, and they are required to continually keep this under review. So if circumstances change and the suspension no longer needs to be applied, they should be looking at lifting the suspension. They can also extend suspensions. So that's would normally be by a further 12 weeks. The purpose of a suspension is normally to allow a provider either time to make improvements or for Ofsted to investigate concerns that have been raised to decide on next steps, whether that be lifting the suspension, whether it be imposing cancellation on a service, or whether it be a lesser severe action such as restriction of accommodation or the issuance of compliance notices. But the suspension is a very impactful type of action. Your registration isn't cancelled, but you are not allowed to be accommodating children, so it can have a very significant effect on a service and the young people accommodated there as well. In terms of cancellation, again, there can be urgent and non-urgent processes. If there's an urgent cancellation, then the service would have to close as soon as that cancellation has been served. So obviously that's a very big impact on the provider, because again, children would have to be moved out immediately, or else they'd be carrying out a statutory offence if they were to continue to accommodate young people at a service. It's the highest end of Ofsted's enforcement powers, and they'll only do a urgent cancellation if they believe that there is a certain level of risk that young people will be put at the risk of harm, or will or may be put at the risk of harm. And this is all set out under the Care Standards Act.
It's also important to note that in relation to urgent cancellation proceedings, that this occurs in the Magistrates' Court. So Ofsted would have to make an application to a Magistrates' Court, which is normally done with notice to the provider. It doesn't always have to be. So a provider might actually find that they have to appear before a magistrate and prepare a case very quickly, and in order to put forward statements as to why they believe that the cancellation shouldn't take place.
And obviously, it's useful to note that with the slow cancellation process, it doesn't take effect immediately. Again, as with the suspension, you'd have the opportunity to submit representations to Ofsted within that 28-day period. If they still want to cancel, then there's the opportunity to appeal to the tribunal, and the cancellation wouldn't take effect until either the date that the tribunal made a decision that it should, or if the provider decides to withdraw their appeal to the process. Now, one of the key things to consider in terms of cancellation is that there's also an impact in terms of the disqualification regulations kicking in. Now, these are a very complex area of law, but basically, if a person has been involved in the management or has a financial interest in the running of a children's home that has been subject to that has been cancelled by Ofsted, then under certain disqualification legislation, they may be prevented from having any interest, whether financial or being a manager or working for a children's home in the future. And also it relates to private fostering arrangements as well. So there's a big knock-on impact there. I mean, there's provisions for Ofsted giving permission in writing to allow them to have an interest, but there is this automatic statutory kind of ban on that, and we find a lot of providers aren't aware of that, and they really should be, because it is a big risk. And so it makes it even more important that they should be looking to challenge cancellation proceedings if they are wanting to continue to operate in the children's home or in the childcare sector, because there are these implications that need to be taken into account.
Okay, thanks both. So we've discussed some of the implications of some of the particular types of enforcement action. Are there any other potential implications that providers should be thinking of more generally?
Well, I think absolutely. I mean, Sam has mentioned the disqualification regulations where a children's home has had its registration cancelled by Ofsted. So that obviously has an individual impact for people on their future careers. In addition to the other sorts of enforcement action, well, of course, there can be a loss of revenue where there's a suspension or a restriction of accommodation. There can be loss of reputation, which could be very difficult for a children's home particularly to ride back from. They could also be ultimately the loss of the business through a cancellation. So there's plenty of negative impact that Ofsted enforcement action can bring. And as Sam has mentioned, it is so important for providers to actually consider their position. So when they receive an enforcement notice from Ofsted, to really think about what they want to do with that particular notice. Of course, we've been talking about high-level enforcement action, but quite frequently these sorts of enforcement actions start off at a much lower level, and providers have been given ample warning for this sort of enforcement action to be ramped up. It can often start with a poor inspection report where Ofsted has provided a rating that a provider is not happy with. But they may also issue things such as compliance notices or warning letters. So it's actually very rare for a provider to receive this high-level enforcement action overnight without any warning. It does happen, but often there are warning signals beforehand.
Thanks, Caroline. I think there's a lot to think about there. That's all we've got time for today. So thanks to both Caroline and Sam for that helpful overview. Thank you for watching, and we hope you found that useful. If you do have any questions on today's video or have any other topics you'd like us to have a look at, please do feel free to get in touch. Our contact details will be available on the screen in a second.